Karen and Jocelyn, are we waiting a couple of minutes for folks to join up, or do you guys want to go ahead and get started?
I think we go ahead.
Sure, yeah, I'll go ahead and introduce you. So welcome everybody. Today we have a presentation from Karen Putzier and Jocelyn Rothchild. It's entitled Crime Victims Compensation Program, Financial Assistance for Victims of Crime. A little bit about our presenters today. Karen Putzier is a crime victim case manager and has been with the program since 2015. Her role is to help determine the eligibility of benefits for victims from mainly southeast and southwest areas of Idaho and assist eligible victims and their families with understanding the benefits that are available to them. She also helps facilitate access to those benefits. Karen has a Bachelor of Science and Master of Arts in Criminal Justice from Boise State University. Prior to working at the program, she was a misdemeanor probation officer in Canyon County and a felony probation and parole officer in Ada County, primarily supervising domestic violence offenders. Jocelyn is also a case manager for the Crime Victims Compensation Program. She has been with the program since 2011. Jocelyn graduated in 2001 with a Bachelor of Arts in Psychology from California Baptist University. Prior to beginning her work with the program, Jocelyn has accumulated extensive experience working in adult protection and child welfare services, administering in-home support for elderly individuals, and working with community-based mental health services. So again, their presentation today is entitled Crime Victims Compensation Program, Financial Assistance for Victims of Crime. Welcome everybody, and I will turn it over to our presenters.
Good morning. Thank you all for being with us today. We would like to ask, if you can, that you just post your job title in the chat here in the next few minutes so that we can kind of get an overview of who we have with us. And basically, we're just going to walk you through how the program works and kind of specifically how our application process works. And then we would be happy to answer any questions that you all have. So I'm just gonna go ahead and get started. The history of the program, pretty simply, is the program was established by the legislature in July of 1986. That is our cutoff point. That's where we go back to. And occasionally we still get applications from the 1980s, people who are looking for benefits for that time period. And if we can find a law enforcement report, we can at that point evaluate that. So the program has served approximately 47,650 crime victims, paid out over 50 million on behalf of crime victims. Over 2,600 new applications were filed during the 2020 fiscal year, and approximately 90% of those cases involved criminal conduct against women and children. Obviously, that is a large proportion of what we handle. So here's how we're funded. We do receive a small amount of tax dollars, and those are specifically for payment of adult sexual assault exams. That is new since 2018. Prior to that, we did not receive any tax funding. We receive a large portion of our funds from fines and fees paid on criminal convictions. So when you are convicted of a crime, there is a fine attached to that, and we get a percentage of each of those fines that are paid. We also get a large portion of our funds through the VOCA grant, and then we do also invest heavily in recovery efforts. So restitution through the criminal case, and also subrogation on cases where most usually where auto insurance is involved. And so if we have paid out, then the auto insurance settlement reimburses us for that. And then we also do receive a small amount of donations. So this is just kind of a look at what our cases in 2020 came in as. You can see there is a huge gap between child sexual abuse and our next largest, which would be domestic violence. It it is a large amount of the cases that we see, but we do also see a pretty good amount of domestic violence, battery, physical child abuse, sexual assault, DUI, and homicide. And then this is just an age breakdown. So this is who we're looking at. Interestingly, when the numbers were updated, there wasn't a lot of change, except the 60+ group has grown over the last 2 years when we were updating numbers and checking to make sure that we had everything accurate. That was the growth place, was in the 60+ age group there. So this is kind of, before we get into the nuts and bolts, this is kind of an overview of how the program functions. So basically, the Crime Victim Compensation Program has 2 main programs. We have the General Compensation Program and we have the Sexual Assault Program. And underneath each of those programs, there are separate benefits. So the Sexual Assault Program is really simple. Under the Sexual Assault Program, we pay for forensic exams, and that's it. Under the General Compensation Program, we pay for medical treatment, we pay for mental health treatment, weekly compensation, and funeral benefits. We'll go much more into depth in all of those. But that's sort of an overall picture for you as we start talking of the two sides to the program and how it all functions.
I'm going to jump on real quick. I'm going to go over the general compensation eligibility requirements, which means that we're dealing with the left side of the screen right now. Everything that I'll talk about is going to go down trickling through the medical, mental health, weekly compensation, and funeral. So I'll give you an idea of what I will be talking about. So in order to be found eligible with our program, first, we need an application into our program saying you're applying to our program. But the crime must have occurred in Idaho. Every once in a while, we'll get cross-jurisdiction cases, and that's just a coordination with the other state determining where that crime actually happened and who should be taking on the compensation for that crime. Every state has a compensation program. So if we can't cover it, we've determined it's not in Idaho, then that other states should be able to follow through the process of their compensation benefits. So the next 2 bullet points, the crime must have been reported to law enforcement within 72 hours of the crime. We also must get the application within 1 year of the crime. There is an exception to this rule. If there is good cause found, and we can either ask specifically to the victim, we can ask victim witness coordinators, it can be already supplied to us in the law enforcement report. And then if we find those good cause, then we will make that exception and waive those requirements. Typically with every minor, we will automatically waive that. We don't expect them to hold themselves to those 2 requirements. And the good causes of that is just the fact that you're a minor, and we just don't hold you to that. So the next bullet there is that you must fully cooperate with law enforcement and prosecution. And we determine cooperation a little bit different than what you would normally define cooperation. Ours is cooperate to the best of your ability. If you are in contact with law enforcement, if you're answering their phone calls, if you're meeting with them, if you are meeting with the prosecution, if you are subpoenaed for hearings and you show up for those hearings, not all victims want to go down the criminal justice path, especially with some domestic violence victims. They may not want charges pressed, they may not want to go through the process, but if they're meeting the expectations of law enforcement and prosecution, that's still cooperation for us. If we've gotten word from either law enforcement or prosecution that the victim is not cooperating, then we'll do a second screening and ask the victim specifically, why is it that you're not cooperating? And if they supply us with a good cause statement, then we can go ahead and waive that requirement as well. So after we've kind of crossed those bridges, then we will use our law enforcement reports and other information, maybe CARES interviews or forensic interview information, and we will then have to determine that there's sufficient evidence that a crime occurred with this victim. A crime does not have to be charged in order to be found eligible with our program. We just have to hit that threshold of there's a preponderance of evidence that we have decided that a crime here has been committed. Obviously, if there is a charge, law enforcement and prosecution have already done that for us. And then we have contribution. So contribution is that if the victim's actions are seen to have contributed to their injuries, then we may have to deny that case fully. We also have options of partially denying it. So maybe a 50% denial, you'll only get 50% of benefits. And this can kind of come into play. We always seem to use this example, but a typical bar fight. Hey, let's take this outside. I want to, fight you, that kind of thing. Both parties agree to go outside. Both parties, whoever ends up applying to our program, or if both, we're going to probably deny that case and say you contributed to your actions for your injuries. Now we'll put a caveat in there and say, we both agree to go out and fight in front of the bar, and then somebody pulls a gun. One of the parties pulls a gun. Well, that wasn't the agreement. And so we may still say your actions contributed, but that's where we get into, we might give you 50% benefits because you agreed partially to that. Or, you agreed to fight one person and then 4 of the other guy's buddies come and fight you as well. That will look at a little bit of contribution. It may be a partial denial, or we may say that there's no contribution there. You did not agree to fight 5 people. So that's our eligibility requirements. We'll jump into, if you're found eligible, what the benefits look like. So if there's any questions right now with that, feel free to put it in the chat. Jocelyn's gonna monitor that as we go through, and she'll chime in if there's any questions on eligibility there. So down into the benefits of our general comp program, that we have a total $25,000 fund for each individual victim that has been found eligible with our program. So within this $25,000, we can pay up to that amount for medical bills. And listed below are some of the typical medical bills that we can pay. I know there was a question very early on in our chat about massage therapy. Yes, we can still pay for massage therapy. It really just will depend on making sure that we get the right documentation for billing requirements. And then we'll, discuss and make sure that it's all crime related, but we have paid for massage therapy. Within that big cap of $25,000, we do have a maximum of $2,500 for counseling. Once we hit the $2,500 in counseling, there is an option to request for additional benefits. That will just be dependent on the claimant contacting our program once we get around that $2,500, and we can start that process. We try to kind of keep an eye out for some of these that are getting close to the $2,500 and reach out and just say, hey, we're getting close. Are you looking to request for additional benefits? If you are, this is how we go about doing it. Not everybody responds to that. So if you have a victim that says, well, I spent all my money, I don't have anything left for counseling, just at least have them contact our program, and we can at least take a look at their case and see if there's some additional benefits there for counseling. Going along with the counseling benefits, and going along with all these benefits is these benefits are available for the span of their life. So medical treatment might need to be followed up years down the road. We have cases that we pull out and have worked on years after their victimization. Same with counseling. They feel free that the victim can take a break for a while, come back, readjust or reassess and see, hey, I think I need some more counseling, something like that, especially if you have a criminal case going on. They don't think they need counseling, but then all of a sudden court hearings are coming up. Very much just have that victim contact us. As long as we have the application is found eligible and we have that case on file, we'll just walk them through the process of what that need is at that time. So we also offer wage loss and dependent death benefits. So wage loss, there is or with both of these, there's a second screening for this. We have to determine that they are eligible for wage loss and dependent death. So wage loss, you have to be working at the time of the crime, not actively working, but you have to be employed at the time of the crime. And you have to miss more than a week's worth of work for injury related to that crime. So in determining that to be eligible, we have to do an employment verification, and then we have to choose the appropriate provider that they have seen to have them speak on behalf of their disability from working and what that time span was. So the maximum benefit of that is $175 per week. Dependent death on that. So homicide victims have to be employed at the time of the crime. So we'll do that second verification to make sure that they were employed. And then we can look to pay for a dependent death on any dependent children that they would have, as well as if there's a spouse there. Funeral benefits, our cap is at $5,000. We have typical expenses listed there. We have paid for some additional stuff. We've paid for flowers or programs of the funeral. They paid for a memorial bench not too long ago. So doesn't have to be a traditional funeral service in order to be paid, but the cap of the $5,000 is still there. So if the traditional funeral expense is more than $5,000, then we don't necessarily have the ability to be creative in other things that we have paid for other people in the past. So there are certain cases, and it's dependent on crime type. Under homicide, kidnapping, sexual assault, and that's both adult and minors, physical child abuse, and domestic violence, there's a family assistance benefit under that primary victim's case. And so this benefit is $500 per immediate family member with a maximum of $1,500 total. And then we have the definition of immediate family members, parents, siblings, spouses, children, grandparents, and that includes step families. So step parent, step sibling, anything like that. Those applications come out with an eligibility decision with us. So you won't find that application on our website or in the community for the most part. And so if you have a family member that is looking for counseling for themselves to address what has happened to that primary victim, they can contact our program and we can walk them through the steps and see if they're eligible for it and get the appropriate documentation for them to fill out to obtain that family assistance benefit. So those were the benefits. These are just some additional information on our general comp program. We are mandated to only pay for injuries related to that crime. So we don't do property replacement. We don't do crime scene cleanup. Typically what questions we get in regards to what else our program can pay. Traffic related crimes, we don't do the typical accident. The only crimes that we can cover are DUIs, felony leaving the scene of an injury accident, and then the vehicular manslaughter, Idaho Code 18-4006 3B. And the 3B is important because that links them back to the DUI. So it's vehicular manslaughter, and that offender also falls under the DUI Idaho code there. And then just for informational, we are a payer of last resort. So if they have insurance, that is to be billed first. And then we make payments with any remaining balance after that, hopefully leaving the victim with no out-of-pocket expense in regards to injuries or treatment they have sought for the crime. All right, Jocelyn, you want to talk about sexual assault?
I do. Before we do that, I do want to kind of, we've had a couple of questions in the chat that I've answered in the chat, but I want to just throw them out there, make sure that everybody's hearing the information. So we had a question about if the crime happened in California and you filed in California, but then you moved to Idaho and you have doctors or hospital bills. And in order for you to be eligible and for us to pay, the crime has to have occurred in Idaho. However, in our case, if you were injured in Idaho and you moved to California and had bills in California, we would continue to pay those. I believe California is the same, but I can't speak for the California program. But I can tell you that if the situation was reversed, Idaho would continue to pay your medical bills as long as they were crime related. And then the second question we had was an example of good cause. So the examples that I put in the chat were just if you have a domestic violence situation and your victim waits for the offender to go to work on Monday, or waits till a time period has passed and your victim feels safe reporting, as long as we get that information, we're going to find that to be good cause. We've also had people who have been hospitalized for a couple of days, whatever their injuries were resulted in a need for surgery. And so they're in the hospital for the next 4 days. Well, we're not going to penalize you for not calling law enforcement while you're in the hospital recovering from surgery. But we have to know that information. I'm not just going to know that. And your law enforcement report may not share that information because it's not part of the investigation. So you want to make sure that if you're working with people that they're communicating that information to us. And then we just had a question come in about compensation for wage loss due to a victim attending trial. And no, we do not have any compensation for victims attending trial. Our wage loss is limited to disabilities caused by injuries incurred in the course of the crime. So it has to be a disability situation in order for us to reimburse for wage loss. And I'm going to give it another second, see if there's anything else that pops up. Okay, we're going to change gears a little bit and talk about sexual assault forensic exams now. In order for, well, okay, let me go back. The program is mandated by law to pay for sexual assault forensic exams in the state of Idaho. The crime has to have occurred in Idaho. These exams can be done without law enforcement authorization as a Jane Doe process, and we can pay those. We get a lot of questions about, well, but do I have to write my name on the application? Do I have to, those kinds of things? And the answer is yes, because you are legally giving us permission to pay something on your behalf. So we have to have your correct information to do that, but we're not going to look for any further information. We do have to have an application. We have to have the sexual assault forensic examination reimbursement form. It's a lot of words. And it has to be signed by an authorized claimant. So we pay these for both minors and adults. And if the person who is being examined cannot legally sign for themselves, then someone who has legal authority to do that has to be the signer. And we'll talk more about that when we go through the applications in a few minutes, but just kind of as a simple way to put that together, if the person being examined cannot legally sign for themselves, then the person who is legally able to sign for them has to be the person signing the form. We did have a change, I mentioned it earlier, in 2018 in the statute, that adult sexual assault exams are billed directly to the program unless there is a federally funded source of payment. So for every other bill, and Karen mentioned this earlier, for every other bill that is not a sexual assault exam, we require that your health insurance be billed first. However, this legislative change allows us to pay for adult sexual assault exams directly unless there is Medicaid, Medicare, or VA benefits. So, private insurance should not be billed for sexual assault exams. If you are if you are assisting someone who is having an exam and they're filling out the form, you want to make sure that the form information is as complete as possible, which can include their Blue Cross, Premera, Regents, whatever. It needs to be on there so that we have an overall view. But the hospital should be made aware, and they are, for the most part, very good about this. But as advocates, just be aware that those bills should come either directly to us or directly to their federally funded source of payment. The breakdown here is kind of to give you an overall picture of how our benefits all work together. So we have, like we said, $25,000. And if you fill out our one-page form, that's going to take you to the box on the right that says sexual assault exam program. And that $25,000 will cover forensic exams, forensic interviews, medications received at the time of the exam. Okay, and I'm not talking about prescriptions that your doctor hands you and you go fill at CVS in a week. We can't help you with those if you just do the one-page form. The one-page form is for forensic exams, forensic interviews, and medications received at the time of the exam. Okay. Under our general compensation program, we have $25,000 available, and that covers all the medical benefits, all the mental health benefits, weekly compensation benefits, and funeral benefits if there's a homicide involved. So there's a lot of numbers that we throw around. What we want you to take away is that the maximum amount that we can pay on any one incident is that $25,000. Okay. Before we go into the application, we had a question: if victims are required to prosecute and therefore participate in a trial, what supports are available for the resulting wage loss? That can be handled. Prosecutors' offices have different resources, and I'm by no means an expert in that. I don't know what each individual prosecutor's office may or may not have. I do know that if restitution is a possibility, we have had quite a few people who have requested their time lost from work in restitution. So that would be my pretty quick and off the top of my head answer to that question. Okay, so would sexual assault survivors need to fill out 2 applications, one for the exam and one for injuries covered under general comp? No, that's a good question. They can. It depends on kind of the timeline. A lot of people go into the emergency room, they have their exam, they don't think they need anything else, they move on, and then in a month they would like some counseling, and so then we get a general application. That happens, but it doesn't have to happen that way. If the victim who is having the exam is willing to report the incident to law enforcement, so there is a law enforcement report, then a full application can certainly be filled out, and then we can take our whole process on, and if that application is found eligible, we can pay for their counseling and any further medical and that sort of thing. So it can happen either way. We don't have a requirement one way or the other, because we understand that at the time, maybe the exam is all you wanted. And we actually have them quite frequently that we pay for the exam, and then a month and a half later, that victim has decided they're ready to report the incident. And so those things get locked up, and now we have a law enforcement report and a full application, and we can move forward with general benefits. So that's a good question, Shayla. Thank you. Is that enough information? Does that answer your question? Okay, great.
Okay, so now we're just going to kind of go through the nuts and the bolts of our application. And so this is our 5-page app. This covers the general comp benefits, and that's what I spoke about earlier. I'm going to go through the skeleton of our actual application, and then Jocelyn's going to fill in with some examples or some scenarios that will help you understand what we're kind of getting at with this. So section 1 here is information about the victim. And so this would be the victim of the law enforcement report that you have. This would not be a family member. This would not be really anybody but who specifically is in that law enforcement report as a victim. Joss, you want to give a?
Yeah, so the most common way we see this, we understand why, we just have to go back and fix them when we get them. But the most common way we see this is when there has been a homicide. And so the person who is filling out the application puts their information in the victim section. And so then what we have is we have a victim who is not deceased, and we have a crime type of homicide. And so normally we can figure that stuff out pretty quickly, but sometimes we get those applications and it's kind of like, wait, what's actually happening here? But the other times when we can see it is if you're filling it out for your child. If your child is the victim of the crime, then your child needs to be in the victim section. And there's a section further on that we'll get more information on.
Yeah, so another part of that section 1, it has to still do with the victim. And this goes into our wage loss, our weekly compensation benefit that we would have. So did the victim miss at least a week's worth of work as a result for the crime? This is, again, as Jocelyn was saying, this is not the parent of the victim who missed work. This is the victim. And you may not know this right away in meeting with that victim, because it might have just happened. And you don't know if the injuries are going to prevent them from working, or you don't know, maybe you don't even get the information if they were working at the time. And we follow up with that later on. But again, this is not any additional information, but if the victim missed work due to this injury.
So Tasha just asked a really good question. If someone was a victim of a crime several months ago and lost their job as a result of missing work due to the crime, would they be eligible for wage loss compensation if they were later employed somewhere else? The most important piece of that question is they lost their job due to missing work due to the crime. So where I would need to delve into is, why did they miss work? Did they miss work because they were injured? And injuries are not just physical. Mental health injuries are taken into account as well. I do want to clarify that. So if you have a client who is suffering from severe PTSD and they can't go back to work because of it, that is something that we should investigate. We should look into that and determine whether or not we can help in that situation. So the most important part of that, there's nothing in Tasha's question that that would disqualify someone from receiving weekly compensation benefits. The investigation that we'd have to center around would be, why did they miss work resulting in the loss of their job? And what we would do is we would pay for the time that they were unable to work, which may be the whole time until they were employed again, and may not be. But the most important part would be showing that disability from work and how it ties back to the crime.
Okay, and so then in section 2, this has to do with only deceased homicide victims. So we will need to know if they were employed at the time they were killed. And then if they were, do they have dependent kids, anyone under age 18, and married? Somebody who is dependent on their income, but they would have to have been employed at the time of the incident.
We see this filled out a lot with victims who are not deceased, and we just don't do anything with it. We can't do anything with it. The purpose of this section is in order for us to kind of know who to look at as far as dependent death benefits. If this is blank on a homicide application, we're not going to go looking for any further information to pay someone dependent death benefits. So in this case, kind of the reverse, this is important on homicide applications, because if that person has kids, I don't know that until I can see it, you know, until someone tells me. So I may completely ignore the employment information here because I don't know that there are dependents who could get paid. So that's why this section is central in those homicide applications.
Okay, so section 3, move my thing here. It says if you are signing this application for a minor, incapacitated, or deceased victim, the following information is required about you. So if you are signing this application on behalf of the victim, this information is your information.
When we boil it all down, what this comes down to is who is legally responsible for paying any bills that are incurred as a result of this crime. So this is why we can't have the next door neighbor who brought the kid to the CARES interview sign the application, because legally that person isn't responsible for this child's bills at all. So that's why we say it over and over again, that if that person cannot legally sign for themselves, then the person signing the application has to have legal authorization to do so. So a parent, a step parent, if grandma has guardianship, that's great. Grandma can sign the application, but we have to have the guardianship information that shows that legally she can do that. Health and welfare, this is a section where we end up searching for who can sign this application frequently. And that's okay, because we want to find this kid eligible or this person eligible if we can at all. But we also want people who are assisting with applications to understand why we're asking for that information and why we're continuing to dig when you've identified for me that that's the next door neighbor. Well, that's nice, and I'm glad the next door neighbor helped, but we have to have that legal ground to stand on.
Okay, so section 4 is all about the law enforcement piece of this crime. This section is important to us. We very much need to know what type of crime we're looking at, the date of the crime, especially if it's a delayed application, the location, so the city, the town. That helps us if you don't know exactly what law enforcement agency showed up. We can narrow that down to, all right, was it the county sheriff or was it police department? And then the investigating officer. Many of us case managers know which officer comes from which agency. So if you don't have the right law enforcement agency written there, we might be able to decipher who to get this law enforcement report based off of the investigating officer. And then the report numbers, that's just gold. So if you have the report number, then we know exactly what report number we're asking that law enforcement agency for. We ask for the person who committed the crime, so the offender there, and then how that person's related to our victim. The description below is very helpful. We do see a lot of applications filled out that says, just see the law enforcement report. But sometimes the law enforcement report that we get isn't matching the information that you supplied in section 4 here. So the type of crime, that's not really linking up. So we're trying to figure out, do we have the right application with the right law enforcement report? So going back to one of our eligibility requirements is that we have to find a preponderance of evidence that a crime was committed. Our main source of information to determine that is a law enforcement report. So when filling out this 5-page app, the crime does have to be reported to law enforcement. So I know that was a question in the chat, I believe from Kathy. So if they're filling out this application, it must be reported to law enforcement for us to then request for that report, and then we can use that in determining our eligibility. I believe, Kathy, the time where you heard you don't have to report it to law enforcement is when you have a sexual assault exam done. Jocelyn will go over this a little bit more in depth down the line. But when you have a sexual assault exam done and you don't want it reported to law enforcement, you fill out that 1-page app, submit that. You can be Jane Doe. We will ask for your information so that we can pay that bill, but we don't ask law enforcement. We don't go anything else. We just collect those bills and we pay it. And that information gets stored in our office as confidential as law enforcement would have it as well.
So this section is really about efficiency and time. We can usually figure out most of this information. We can usually fill in the dots enough to get this entered into our database and start making requests. But it's going to take us a lot longer to gather the information that we need to get this on the case manager's desk to determine eligibility and to move forward with benefits. And meanwhile, there may be bills waiting for us to do something that we can't do anything with until we gather this information if we're missing a lot of these pieces. It matters because, first of all, again, that preponderance piece is one of our baselines. We have to have that. And if we don't have any information on law enforcement, we don't know where to begin. We don't know where to go looking. We don't have any idea, what happened or when. So this piece is important because it allows us to work well with our law enforcement partners to say to them, here's the report number and the dates, and they said it was with you. And the law enforcement agencies use different templates for their numbers. They know when it's a report number that comes out of their office or if it's from someone else. So if we have the report number, it's a very quick process for us to send that request to them to look at that and go, nope, that's not ours. A lot of times, because there's multiple agencies in locations, they actually will look at that number and say, that's not an Idaho Falls police number, that's a Bonneville County Sheriff number. And then we have the answer just that fast. So as much information as you can possibly give us in this section will smooth out our information gathering process immensely. And there are applications frequently that we have to wait 3 months on to get a report because we've spent that 3 months sending a request and then getting one more piece of information, incorporating that, sending another request, getting one more piece of information. Whereas if we have all that up front, then we just send that request, they send us the report, we move on. So that's why this is important, is that there are, for a lot of people, medical bills that are just waiting to either be paid or be sent to collections. And we're rushing around trying to find the right information so that we can move into that process. So as much possible information as can be here, please use it.
Okay, section 5 is statistical information. Very much helpful. It helps us it helps us with our compliance with federal regulations. It's just the bare bones of what they ask us to collect, and then we report on. So that helps with our VOCA funding, that kind of stuff. So if you have that information, it definitely does help our program in general. Okay, so section 6, like I said, we're a payer of last resort. So we're gonna wanna know who this, this victim, whose insurance is covering the first part of that, and then where we can follow up and pay the remaining balance. The more information, the better. If they say they have Medicaid, please write yes. I don't care if you have a Medicaid number or not on them. just please at least say, yes, we have a way of verifying Medicaid on our end. The other thing is say, yes, I have insurance. I think it's Blue Cross. I don't write that. She says she thinks it's Blue Cross. Any information is helpful, because again, this slows down the process of paying for bills. If we don't see that they have insurance, and then somehow we trickle in and we get information that they do have insurance, that bill then gets pended for us to gather the explanation of benefits for that insurance. And it just ties up our ability to pay faster than if we didn't have that information.
We also need this information if you are working an application for an auto case. It is very important that we know what the auto insurance is as much as possible. If there is any possibility that there is insurance, please don't leave this section blank. It really hamstrings us once we get to the point of eligibility and paying things. Not only that, but if we pay it and then we find out there's insurance, we have to ask the provider for a refund. They have to process that and refund us the money. They then have to bill the insurance. Then they have to bill us again if there's anything remaining, and then we pay them again. So it just really draws out the process when we want to get those bills taken care of as quickly and as efficiently as we can for you.
Yeah, I'm kind of going with that real quick is if the provider wasn't aware of insurance, they might be stuck under a timely filing issue with them being able to bill the insurance. And then that really trickles down to us having a conversation of, are we now primary? And it gets a little sticky. So if we can avoid that and just have a little bit of information coming through the application, that really helps us move forward with paying those bills as fast as we can.
We do hear frequently, no, I didn't give them my insurance information because I thought you guys would cover it. So we really need advocates in particular to communicate to people that just because you may be found eligible for the program does not mean that your insurance no longer applies. Your insurance will still most likely apply. If you have a deductible, then we're going to help with that. But your providers and us and anybody who needs to know that you have medical insurance so that we can figure out how and who to do all of the billing the most correct and quick way possible.
Kind of down there, it's not outlined at all, but if the victim or the claimant is represented by a private attorney, this we usually see again in auto insurance cases. That's very helpful. We have worked closely with attorneys in the area or in the state, and we very much don't want to derail that attorney's process on what they're trying to do for their client. So sometimes they are able to negotiate medical bills down far less than what our med fee schedule can handle. So if we pay that and they were able to have an agreement with that provider on adjusting that to a lower rate than what we paid, then it's not really in the best interest of that victim. So we want to work with the private attorney to make sure that we are basically doing what's in the best interest of that victim, and they're the ones that will know that information the best. So number 7 down there, this is for any medical providers that you are aware of that this victim has seen as a result of the crime. So this is all doctors, dentists, clinics, ambulance. We see a lot of times, oh, they went to West Valley. Okay, did they go on their own or were they transported? We can probably figure that out by the law enforcement report, but we don't always catch those. They're not always in the law enforcement report of figuring out how that victim got to the hospital. Jocelyn, you got any more on that?
Well, it's just, again, it's that more information, the better. If you don't write it down, I don't have any way of knowing. Sometimes we may catch in a medical record that there was, so arrived by ambulance, or that a surgical procedure was done. But you cannot assume that we know what's going on with your medical care or with your client's medical care. We have to be told. We request billing documentation from those providers. There's specific information that they have to send in to us. And so if they're not on that list, then we don't know to send that request. And if we don't know to send that request, then they don't know that we're involved, and they're going to keep billing the victim. And if they don't receive payment, then they're going to send the victim to collections. And I have many times received phone calls from victims saying, wait, this bill got sent to collections. I thought you were going to take care of my bills. And when we go through the list, I did take care of some of the bills, but not the ones that I didn't know about. So it matters. And if the application comes into us and then a week later, they have to go back to the emergency room, they go to a different emergency room, they decide to go to a chiropractor, I'm not going to have that information because it's not on the application. So that's something to keep in mind as well, is that we need to be updated on that too.
Okay, we're just gonna go through this real quick. I want to leave it open for a Q&A at the end. So this is just our release of information. This very much needs to be filled out without all 3 signatures highlighted there and dated. This is not a valid application. We cannot do anything with this. This is our key to get providers to send us medical records and billing and any other documentation we need in order to pay on these bills. So if we don't have a valid signature page here, the provider will say, I'm not going to give you any of that. You don't have that release. So that's kind of the first part. The second part is, the repayment and subrogation agreement. We kind of talked through that in the very beginning of where our funding sources come from. But they have to agree to that part of the release, as well as sign the bottom, which says everything on this application is true and accurate. So this needs to be signed by the claimant, the appropriate person. As noted there, it's the person who is either the victim in section 1 because they're an adult and they're signing this application for themselves, or the person in section 3 as they are filling this application on behalf of the victim. So it needs to be signed by one of 2 of those people. And we'll go over that again here. So again, you must have a valid claimant to sign the application. So victim in section 1 or legal guardian in section 3. Must have the crime type information filled out in section 4. If that's blank, we're going to have to send it either back to the person who sent it to us and have them fill it out, or even maybe to the victim to have that section fill that out, which again slows down our process. And then overall in the 5-page act, the more information provided on the application, the more efficient we can be as a program. So anything and everything written on there is very helpful. It's also very much open. If you have a question on how to fill out the application, or you have a victim, you're like, I don't quite know if this is the right crime type, anything like that, feel free to give us a call. I had a victim witness coordinator email me this morning about a vulnerable adult case, and she very much wanted to figure out how to fill out section 4. We went through that and we got through it. So feel free to contact us too. It's not end all be all. You have to know how to fill this out. We want to find these cases eligible. So if you have questions in order to fill that application out, we very much appreciate the phone calls coming in so that we don't have to run around afterwards. Jocelyn's going to go over the 1-page app real quick, and then we'll open it up for questions.
So this is just going to be very quick and simple. This is the 1-page application. This is the information that we absolutely must have. If we get in an application with any of these pieces blank, we're going to be in trouble. We have to know who the victim is. We can't request medical records or bills from St. Luke's if we don't have a accurate victim name and birth date. The legal guardian has to be the person signing the application. Whether that's yourself or your parent or your grandmother. We've, been over this. We will go seek this out, and it will slow things down terribly. And we all know that when people get, even if it's just a statement in the mail that only kind of looks like a bill for a sexual assault exam, that it's re-traumatizing. We don't want that to happen. And we do rush sexual assault exam payments. But if we don't have complete information, we can't pay it. So got to have the legal guardian, and that has to be the person who signs the application in the next section down under the authorization to release information. We have to have the date of the examination. We can't just ask the hospital for any date between here and here and expect them to send us what we need. We need the date of the exam. And then again, we need the facility examination, or the facility that did the examination. We get these in fairly frequently, and that section is blank. I don't know who to ask for your bill at that point. Usually what we do is we kind of try and figure it out based on your location, and we ask some really gentle questions, but tell me where this happened so that I can contact them, ask for the information on that date with your authorization, and then we will get that thing paid and out the door extremely quickly. Again, you've got the insurance information under that. If you have Medicaid, please let us know that. Medicaid's going to take care of that. If you are a minor or your child is having the exam, if you're a minor, don't sign the application. If your child is having the exam, we need to know who the insurance is through, and then we'll take it from there. We also have this section down at the bottom that even though the victim is signing, even though this application is the victim's information primarily, we have this section at the bottom that says patient should not be billed for sexual assault exam. No patient should be billed for a sexual assault exam. It should be paid by their insurance or by crime victims compensation. That's it. There should never be a hospital or a clinic that sends out a bill on a sexual assault exam. So if that happens, we want to know that. If your client comes to you and says, I just got a bill on this thing, we need to know that. Now, most of the hospitals are really good about it. Sometimes they slip through, but that's why that's down there. I did see a question about where you can get the application. All of our applications are, both the general application and the sexual assault forensic examination reimbursement form are on our website, which Karen put in the chat, and they are in English and in Spanish. So please feel free to go get those and to use them as frequently as you have use for them. We want those to be available. And like I said, we have to have this form to pay the sexual assault exam. This is our requirement. We have to have this form to pay a sexual assault exam. So that's kind of the quick overview of the form as it relates to the program. This is our contact information. And you can also email us through the website. And I know that a lot of people who are on here have direct contact information, and that's okay too. If you have our email addresses, if you have our direct phone numbers, use them. We want to talk to you. We want to know what problems you're having, and if you're running into issues, and what's working. I mean, if you have found some way to do something that's working, let us know and we'll pass the word. So we are now open for questions. You can attach your agency release of information. On our end, our release actually covers your agency, but I know that doesn't mean that it works on your end. So if you want to attach your release of information, you can do that as well. just sort of more on that note, we will do everything we legally can to work with you, to work with your client. We want to make sure that people's needs are being met as much as we possibly can. And so send us that release or call us and talk to us and see what we can do. We figure it out. We frequently have, email conversations that include victims, or phone conversations that include them. Or like I said, we will accept your release. We're free to talk to you based on our release, but in order to make sure things are smooth, we're not going to argue about that. Any other questions?
Yeah, I know someone asked about the handout. Phoebe, I don't know if maybe just you can email me and I can send out the handout or the slides. I don't know what the best option for that is.
Oh, they were asking about the slide deck.
Yeah.
As far as the slide deck goes, I think, yeah, that would need to be provided from you. If there were any handouts related to your presentation that you provided to the organizers beforehand, I think those would be located with your presentation information on the agenda. But if it's the slide deck that you haven't provided to the organizers, then I think that folks would need to contact you for that.
Oh, okay. And I could I'll just put my email address in here. I don't mind emailing the slide if you contact me. If I remember my email.
Thanks, Karen.
Any other questions or any situations that people have run into that they'd like to they'd like clarification on or to discuss?
We might be ready for lunch. Okay, well, you have our contact information up there. I threw my email in there too. It's not my expertise to answer that question. I'll get it off to somebody who can. And then let us know if you have any questions. It's hard to fill out the application. You have questions on that, or if we have an application on a victim already, feel free to just pick up the phone and give us a call. We're happy to answer anything to help the victim get services they need. So.
And I just wanted to do a quick thank you to our wonderful presenters. Thank you everybody for being here. Mary, our tech, put the evaluation link for today's session in the chat. So go ahead and fill that out if you haven't done so already. And I think she just put it in again. And it can also be found on the resources page.
All right, well, thank you everyone.